the word qualifying in front of,
For page 9 you're on?
page, yeah, 3 or more qualifying felonies. That would be for both charge ID ending in 42C and 43C.
Oh, okay.
And that's consistent with the language that you have in the stipulation.
I agree.
And then I put the stipulation in at the very end of 42C and 43C. So I can show you that if you want, and of course I can give you revised copies. I will give you revised copies. You want to see?
It's not clicking, I think,
Yeah.
what you're saying
So,
to me.
as we talked about yesterday, we talked about adding the stipulation. So here
Your Honor, this is House Detective Jack Dunleavy.
Be careful what you want here, please. Take a seat.
If you could just remain standing. Do you swear that the testimony that you're about to provide will be the truth and nothing but the truth under the pains and penalties of perjury?
I do.
You can make yourself comfortable. Can you start by stating and spelling your first and last name for the record?
Sure, it's Detective John Dunleavy, JohnDunleavy.
And is John the name that you go by?
It's my legal name. I go by Jack.
Okay. Detective Dunleavy, how are you currently employed?
With the Manchester Police Department.
Since when?
2015.
And what is your current case assignment with the Manchester Police Department?
Currently, I'm assigned to the Juvenile Investigation Division.
And are you a detective with the Manchester Police Department?
I am.
How long have you been a detective with the Manchester Police Department?
Since 2018.
And what are your duties as a detective?
I handle all of the physical and sexual abuse of children in the city.
And so you mentioned your time with the Manchester Police Department. Any prior law enforcement experience?
I was with the Winchester, New Hampshire Police Department for about 2.5 years.
Prior to that, did you graduate from the police academy?
I did.
What year were you?
2013.
And what class?
162nd.
Can you, just briefly for the jury, describe your role and involvement with this case?
Sure. So for this case, I'm one of the co-leads with Detective Rahill for this case. My involvement started about February or March of 2022.
You mentioned Detective Rahill. Is that Max Rahill?
It is.
And you said that you're a co-lead with Detective Rahill?
I am. He's my partner.
Were there any other Manchester police detectives that worked on this case?
There were dozens.
Were there other law enforcement agencies involved in the investigation of this case?
There was.
How many would you say?
The FBI, ATF, the U.S. Marshals, Department of Corrections, the sheriffs.
Did you participate in interviews for this investigation?
I did.
How many people would you say you've spoken to or interviewed in this case?
Dozens.
How many hours have you spent investigating this incident?
Hundreds of hours.
And are you familiar with the defendant in this case, Adam Montgomery?
I am.
Do you know who he is?
I do.
Did he at some point become a person of interest in this investigation?
Yes,
And do you see him here today?
I do.
Can you point him out?
Sitting with a white shirt next to his attorneys.
And can the record identify that the witness has identified the defendant?
The record shall so reflect.
Were you the original investigating officer on this case?
I was not.
And can you just tell us how you became involved?
I became involved it was like late February, early March of 2022. Myself and Detective Rahill worked on the case together.
You mentioned that at some point the defendant became a person of interest on the case.
That's right.
And what led your attention to the defendant?
There was information that had been obtained through Kim Frayne identifying him as a witness.
Was one of the individuals that you interviewed in relation to this case a gentleman named Mark Reed?
It was.
During your interview with Mr. Reed, did he consent to a search of his Facebook account?
He did.
And did you review those messages?
I did.
Were you able to locate an account identified as Adam Montgomery's?
Wasn't able to identify the name. I was able to identify the Facebook URL.
And was that a number combination
It was.
associated with a deleted account?
Yes.
And so you weren't initially able to identify the account associated with that conversation?
No, it had been deleted.
Were there statements within that communication that led you to the identification of the person that Mark Reed communicated with?
Yes.
And can you tell us what that is?
Through the messages between that deleted account and Mark Reed, there were audio messages. There was the mention of 77 Guilford Street. There were phone numbers associated with the Montgomerys. There was a photo of a family pet that they had with one of their children laying next to it, which was associated with one of their other Facebook accounts. Things of that nature.
And when you say their Facebook accounts, they had, who is they?
Adam and Kayla Montgomery.
And you mentioned 77 Guilford Street. Are you familiar with that location?
I am.
And who do you believe to have lived there back in October 2019?
So in October of 2019, it would have been Adam, Kayla, Declan, Seamus, and Harmony.
You mentioned one of the phone numbers, or you mentioned several phone numbers associated that led you to Mr. Montgomery. Was one of those numbers 603-858-5597?
Was provided to Mark Reed on October 3rd of 2019 in that message exchange between that deleted account and Mr. Reed.
During your participation in this investigation, did you interview an individual named Kevin LaBelle?
I did.
How many times did you speak with Mr. LaBelle concerning this investigation?
3 times.
Did you meet with him on April 28th of this year?
I did.
What was your purpose of meeting with him?
Detective Rahill and I had met with him at the state prison to ask follow-up questions in relation to the gun case that we're here today for.
Prior to speaking with him, had you also received information from Kayla Montgomery?
I had.
Was that one of the purposes for speaking with him?
Yes.
What was your goal there?
To corroborate the information that she had stated to Mr. LaBelle.
And as a detective, why is corroboration important?
Credibility.
During your interview with Mr. LaBelle, well, can you just describe what that looked like, this last interview that you mentioned on April 28th?
Sure. So the purpose of us going there was just to clarify, that in particular, and then ask any follow-up things. Basically the way the interview started is I told him, we're not here to talk about...
I'll rephrase the question, Judge. Did you sit down with Mr. LaBelle at some point?
I did.
Did he offer you information without being prompted?
Sustained.
I want to switch gears, Detective Dunleavy. You mentioned 77 Guilford Street, that you were familiar with that address. What sources of information did your familiarity come from?
I knew that there had been police reports at that address with the Montgomerys during that time period.
And were you aware of an eviction?
I was.
Did you interview multiple people from the Guilford Street address that were living there at the time?
I did.
During the course of your investigation, did you review Facebook records related to an Ishmael Garcia?
I did.
How did you obtain those records?
Through a search warrant.
Did you look specifically at any specific, or did you look at any specific periods in time at those records?
I did.
And in those records, were there any messages regarding the sale of guns, the sale of firearms?
No.
And, which may we approach?
Yes. is sustained. The last question and answer are stricken.
You mentioned that you reviewed those records during a relevant time period.
I did.
And what was that time period?
I believe it was the September 28th, 29th until October 4th, 5th. I went a little bit further out.
At some point, did Mr. Garcia become a person of interest in this investigation?
Not for the theft of the firearm or the rifles, no. Or the shotgun and the rifle.
During the course of your investigation, did you review a cell phone extraction from an individual named Jonathan Sargent?
I did.
And during your review, were you able to identify contacts stored in that cell phone device?
I was.
Okay. I think,
Approach?
So, Detective Dunleavy, I'm just going to back up and recap. I think you testified that you had reviewed a phone extraction related to a Jonathan Sargent.
That's correct.
And you said that you had reviewed the contact information associated with that extraction.
Yes.
In that extraction, was there a phone number that you were familiar with?
There was.
And what was that phone number?
603-858-3393.
And was there a name associated with that phone number in Mr. Sargent's phone?
Overruled.
Sorry, was there a name associated with that phone number in Mr. Sargent's phone?
There was.
And can you tell the jury what that name was?
Adam Montgomery.
If I may approach the witness, Judge.
Yes, you may.
So, Detective Dunleavy, you previously testified that you were familiar with Mr. Reed's cell phone conversation with the defendant.
Correct.
And I'm going to ask you to take a look at that. And if you could hold that up for the jurors to see. And can you point to the number that you recognized on Mr. Sargent's phone?
Right down here at the bottom.
And can you read it to the jurors in the back?
603-858-3393.
Did you search for any other numbers or contacts on Mr. Sargent's phone?
I did.
Who did you search for?
Ishmael Garcia, Hector Rivera Ayala.
And did you also look under their aliases, known aliases?
I did. I looked under Ish. I looked under Manny.
Did those searches yield any results?
No.
I want to switch gears and talk about another role that you have as a detective. Do you have access to phone calls made by inmates at the House of Corrections here in Manchester?
I do.
Can you listen to those calls as they're occurring?
I can, yes.
And can you tell me about those calls? What happens when you press play on one of those calls?
As soon as the inmate would pick up the phone and start entering their PIN and associated information, the recording would start through the jail, and I would pick up that, and then as soon as the phone call started, it would also start recording that until either the caller or the person that received the call hangs up, then the recording would end.
And you mentioned a PIN just now. What is a PIN? What did you mean by that?
A PIN allows the inmate to access their account, so nobody else can use it.
So that's a specific identifier?
It is.
And that initial message, does it provide the name of the person in the House of Corrections that's making the phone call?
It does.
And you have access to records held by the House of Corrections here?
I do.
Are you able to review those records at or near the time that they're created?
Yes.
Those records with the House of Corrections, are they made for every call that goes in and out of the jail?
Certain calls are private and not accessible to law enforcement, such as attorney phone calls and calls to treatment facilities, such as drug or alcohol rehab.
So calls with a privacy interest you wouldn't have access to?
Correct.
And Detective Dunleavy, I'm handing you, it's been marked for identification purposes as State's Exhibit 43, and I'm going to ask you to take a look at that. Do you recognize what that is?
I do.
What, can you tell us what it is?
This is a portion of a jail call with Mr. Montgomery and his father.
How do you know that?
Because I've listened to every call that he's ever made, and I know from reviewing this that this is that call.
Do you see something that indicates that you've reviewed it?
My initials in top left corner.
And is that a fair and accurate portion of that recording that you listened to?
It is.
Your Honor, at this point, I'd move to strike the ID, mark as full.
Any objection?
No, Your Honor.
The ID is stricken, it's entered as a full exhibit.
You said you're familiar with you said you've listened to every single one, essentially.
Yes,
You're familiar with the defendant's voice?
very much so.
You've had personal interactions with them related to this?
Yes.
Your Honor, I move to publish.
Any objection? You may proceed.
He's going chilling. I was at her house, he was chilling, boom, whatever. She was going to bed, boom. She was going to sleep, falling asleep. I was falling asleep. We were waiting for this kid to come back to the fucking house. I'm like, all right, yo, I'm out of here. All right, cool, boom. And jetted.
You've heard that portion of that audio clip before, correct?
I have.
And was that the defendant's voice we were hearing?
It was.
Do you know who he was speaking to?
His father.
And at the beginning of that call, does it say this is Adam Montgomery?
Yes. Before every recording, the person has to identify themselves by name. And my understanding of their calls is if that name isn't recognized in the call, it won't go through as another added layer of protection to make sure that the inmate's actually the one making the call on those accounts.
Detective Dunleavy, I want to switch gears again. Are you familiar with common terms that individuals use associated with drugs?
For the most part, yes.
Are you familiar with the term TINA?
I am.
What does TINA mean?
Crystal methamphetamine.
If I could have just a moment. Detective Dunleavy, I don't have any additional questions for you. I believe Ms. Attorney Smith may.
Thank you.
I do. Good morning again. How are
Morning. Good. How are you?
you? I'm okay. So let's start with that phone call. Went kind of quick. And I don't know how much everybody picked up, but you've listened to it for a lot, right?
I've listened to it before, yes.
And that recording started out with a dude fucking 3 years ago, bro, 4 years ago, whatever, fucking, supposedly this fucking girl, her house was broken into, right?
That's what I heard.
Okay. And so after he said supposedly this fucking girl, her house was broken into, but it wasn't broken into, me and her were chilling, I was at her house, we were chilling, boom, whatever, right?
I believe that's what I heard, yes, if you're repeating it verbatim.
Okay. And, but that's what you heard over the times that you were listening to
Yes.
it, right?
Yeah.
And it continued saying she was going to bed, boom. Me and she was going to sleep. She was falling asleep. I was falling asleep. We were waiting for this kid to come back to the fucking house. And I'm like, all right, yo, I'm out of here. All right, cool, boom, I jetted. That what the recording said?
Yeah.
So he is talking to his father. And he's talking about something that he said happened 3 or 4 years ago.
That's what it sounds like.
Okay. And he's saying supposedly this girl and her house were broken into, right?
That's what he said.
Okay. And this occurred after he was arrested, right?
This jail call?
Uh-huh.
Yes.
Okay.
He was in custody. It was a jail call.
All right. So I want to move on from that call to some of the other stuff that you've done in this case. Michael Sullivan is someone you are familiar with from this case, right?
That's right.
And in March 7, 2022, you accompanied Detective Ray Hill, members of the U.S. Marshal, and task force members to a location in Massachusetts, right?
Correct.
And you were there to serve a warrant, fugitive from justice warrant, and pick up Michael Sullivan, right?
I was not. I do not have powers of arrest in Massachusetts.
The purpose of being there was to get him arrested on the fugitive from justice.
Correct.
But you bring other people from Massachusetts who have the power to arrest him when you went to Michael Sullivan's, right?
Correct.
But the purpose itself was to arrest him, right?
Yes.
And that was March 7, right?
I don't know the date off the top of my head, but that sounds accurate.
Okay. If I showed you a copy of a police report in that regard, would that help refresh your recollection?
Sure.
Show you a police report. I'm sorry for my highlighting. You don't have to check totally my highlighting.
No, that's okay. Yeah, I see it says March 7th, yeah.
Okay, does that sound right about the time that you accompanied Detective Rayhill, the U.S. Marshals, and a task force to Mr. Sullivan's home?
Yeah,
Okay. You did not arrest Mr. Sullivan at that time, right?
no, we did not locate him.
You did not have any contact with him, right?
No,
You were not able to locate him, right?
correct.
And his wife was there, right? Or a female was there, that somebody within the group that was there talked to, right?
His significant other, yes, she was there.
And then on March 31st, you spoke to Michael Sullivan, right?
That sounds accurate.
Okay. If I showed you a police report, would that help refresh your recollection?
Sure.
Show you a copy of a police report. If you review that and let me know if that helps refresh your recollection.
Yeah, that's accurate.
Okay. So March 31st, you interviewed Michael Sullivan after he had been arrested in Manchester, right?
Correct.
And again, he was arrested with the full task force, or U.S. Marshals, and several police officers, right?
I don't think that's accurate. I think it was just the sheriff's department.
Okay. And he was brought to the station, and you spoke to him with Detective Rayhill.
Yes.
And so if you went to arrest him in Massachusetts on March 7, you didn't talk to him on March 8, 9, 10 through the 31st, right?
Not that I remember.
You were actually looking for him, right?
I'm not sure how active we were looking for him, but we were obviously keeping our eyes out for him.
Right, you still wanted to find him, right?
Sure, yeah.
Okay. And when you spoke to him, it was a lot more than 24 hours after somebody spoke to his significant other in Massachusetts, right? On the fugitive warrant when you were there early.
Can you repeat the question?
I really have to.
That's all right.
March 31st was a whole lot more than 24 hours after you went to Massachusetts to try to have him arrested on that fugitive from justice warrant at his home.
Yes.
And after you spoke to Michael Sullivan on March 31st, a fair amount of time had passed, but you eventually talked to the Hillsborough County Attorney's Office about Mike being useful in the investigation, right?
Right.
The Hillsborough County Attorney wanted to know if indeed he had been useful so that he could determine what to do with the case, right?
You'd have to ask that attorney.
Okay. But he contacted you to ask if indeed Michael had been useful.
Yes.
And you, in this investigation, worked with the Attorney General's office as well, right?
That's correct.
Okay. And you spoke about Mr. Sargent's phone and what it contained and what it didn't contain, right?
Repeat the
On
question.
direct, I'm sorry.
Sorry, repeat the question.
Mr. Sergeant, you spoke about his phone and what it obtained and didn't obtain, right?
I spoke about the contact information that was in there, yes.
And Mr. Sergeant was arrested October 22nd, 2019, right?
Yeah, the 20th or the 22nd stick out in my mind, but yes, that sounds right about the time.
And that was a little over 2 weeks after an AR-15, a .380 Ruger, and a Mossberg shotgun were reported stolen, right?
Right.
And as far as you know, Mossberg shotgun was not, I mean, you know that the stag was located at his place on October 22nd, right?
Yes.
And the .380 Ruger was not located at his place that day, right?
Not that I'm aware of.
And the Mossberg shotgun, also reported stolen from the Frames, was not located there that day, right?
Correct.
But the .380 was subsequently located, right?
Correct.
And did you attend?
Basis? Is overruled.
Did you accompany Detective Rahill to Massachusetts after the discovery of that gun?
To I've been to Massachusetts many times. For what in reference are you speaking of?
Regard to the .380 that was located?
No, I did not.
You also said that, well, one of the other Facebook accounts that you at least did a preservation request for the Facebook account of Anthony Badero, right?
Correct.
And he was known through this investigation sometimes as Tone, right?
Correct.
Okay. And I may have a moment. Thank you very much, Detective.
Your Honor, no further questions for this witness. I'd ask that he be excused.
You may step down. Any objection to his being excused?
No.
Thank you, Your Honor.
You're excused. Does the state wish to call any additional witnesses?
Your Honor, the state would ask with regards to the second stipulation that the parties have entered into. We'd ask for that stipulation to be read to the jury at this time, please.
No objections.
Ladies and gentlemen, the parties stipulate as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying felony convictions as listed under the applicable law. I'm going to read that again, ladies and gentlemen. This is an agreed-upon stipulation of the parties. The parties stipulate as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying felony convictions as listed under the applicable law.
Thank you very much, Your Honor. At this time, having called this witness
Very good, thank you. Council approach for just one moment, please. The state has rested its case. In speaking with the lawyers, it's possible that this case will get to the jury before lunchtime today. We still have a number of things to accomplish, but it is possible. When that happens, we don't have you take your normal lunch break. We actually order lunch for you and we have you eat here. So in the event that this case does get to the jury, I'd like to have your lunch ordered for you. So what I'm going to do is we're going to take an early mid-morning break, and I'm going to send you into the deliberation room. Our jury clerk will come up and take a lunch order, then we'll come back in to resume evidence. After the evidence is concluded in the case, we'll have closing arguments and instructions. That may or may not happen before lunchtime, but either way, you'll have your lunch. I'm gonna send you out now. We'll get the jury clerk up to take your lunch order. We'll bring you back in to resume the case. All rise for the jurors, please. Please be seated. One moment, please. Anything we need to do, or are you just ready to take a break?
We can do the motion before the break or after the break. I actually have two.
Okay. Let's go ahead and do them now.
My first is a motion to strike certain evidence that has been presented in this case by the state. And it is with regard to the video of the movements of the party of people who have been identified as Kelsey Small, Kayla Montgomery, and Adam Montgomery, and putting the phones into the Echo ATM and eventually the phone being recovered. And I certainly understand the relevance of this phone was recovered from the ATM and its address matches the read messages. So that's relevant. However, and I will tell you that I had questioned the relevance a few times, but it was for the state to make their own argument. And I think that they made the argument with regard to the relevance of the Echo ATM and the deposit of the gun, recovery, the deposit of the phone, recovery of the phone, and linking the phone to the read messages and otherwise. However, you will recall that the state spent a significant amount of time reviewing the remainder of the video with the witness, Mr. Dobe, and talking about going through aisles and what they're doing and focusing on the witness here, I believe it was Kayla and Adam here and Kayla and Adam there, and where they're going here and where they're going and how long it takes. And I did not see them make any relevant connection between those activities and the relevant activity of the phone being deposited. And I'm concerned that in this sense, without them being able to make the connection to relevant activity, that the activity is really just sort of character evidence of Mr. Montgomery going around the store with Kayla, and perhaps references to how they were communicating with each other or something when there's hand signals and the like. And I don't think that that has any relevance to this case and is impermissible.
What kind of character evidence do you think that is?
That the only relevance that I can see is them trying to make a connection with disputive behavior between them, where one person is moving in a direction, the other person follows, and there's hand gestures. And again, I could not object because there was relevant information on that CD, but I believe that the state had it impermissibly admitted for an intent to argue character evidence in closing.
Say there's no intent of arguing character evidence. The reason that you had the initial video, obviously, the Eco ATM, which is the transaction of the defendant trying to get rid of evidence that links him back to this crime. The other videos that were shown to the jury, there was one from a middle view, and then there were ones that were from the close-up view to show the identity of the defendant as being that individual who was seen before. As Your Honor will note, other than the initial video at the Eco ATM, none of those other videos were shown a second time. We went through them one time to help establish identity of the folks that were there. And the state is not intending to argue any sort of character evidence from that in its closing. The weight of the evidence and the reason for its admissibility and the reason for being played is showing the identity of the defendant, getting rid of the evidence there, that he is the one controlling that evidence being put into that Eco ATM, even if it wasn't his name that was on that. That is it. So in terms of character evidence, I'm not too sure what else could possibly be argued from that. In addition, that video was exchanged a very long time ago, and if this was going to be a 404B issue, we should have had this a long time ago as well. That particular CD was marked at the day of pre-mark multiple weeks ago.
All right.
I don't see the argument for it being character evidence, let alone the time.
The court does find that it has relevance for the issue of identity. It does appear that that is the purpose for which it is being offered. The court does not see the video as offering character evidence. And even if you could construe any portion of that as character evidence, certainly its probative value is not outweighed by any substantial prejudice, so, or any prejudice, frankly. So that motion is denied.
Now I come to the motion to dismiss charges. Again, the argument is the test that must be considered here is taking the light and the most reasonable, taking the evidence in the light most reasonable to the state. Could a jury find beyond a reasonable doubt that the state had proved its convictions? Proved its indictments, sorry. The credibility of a witness is for the jury to decide, but at some point I think it plays into whether or not the state has met its burden. The state has, let's start with the theft of property. The state has essentially relied on inferences from witnesses that are not credible based on the fact that they have changed their testimony, that they have provided false testimony, and that there actually isn't a witness that said he stole these from the house, with the exception of Kayla saying that he purportedly made admissions to him. When the guns were taken, we don't exactly know from Kim Frain's representations at trial. She says that she was not aware of what happened to the guns, that she woke up and that they were gone. We have a frame of reference for when the guns were taken from the home and not returned, which is Chris Frayne leaving on September 29 and returning on October 2nd. So we do have a time frame for when they went missing. Other than that, the only person who makes a claim that they went missing on the night that Adam went over to see her is her, and again, with the purported admissions by Kayla. So she's not saying that the weapons were taken at that time. She is not saying that Adam took the weapons. She's not saying even that the guns were gone in the morning when she woke up, because she claims that she didn't know the guns were gone until Chris came home, which was that evening. So I don't think, given the lack of credibility of the witnesses produced, I didn't talk about the lack of credibility of Kayla, is similar. I'm sorry, it is a credibility issue, but I think at some point credibility has to come into the assessment of this case and whether the state can prove beyond a reasonable doubt that Adam removed the AR-15 and the Mossberg shotgun from the home. There is a second set, so that would be with the first two sets of first two indictments of theft, one for the Mossberg, one for the Stag AR-15. Then there are two for receiving. And for receiving, we've reviewed the jury instruction that somebody has to have some level of control over the guns. It's not mere possession. Well, possession will do, but there has to be a level of control where the person can control the outcome. I think that there is significant evidence in this case that these guns were sold, that Adam participated in assisting in the sale of the guns, but by reaching out to other people to see if they would purchase it. The presence in the home alone will not satisfy the receiving part. He has to have some level of control in the home, and I think that there's an equal argument that Ish and Manny were in the home with control of the guns and control of who purchased the guns, and that there's no evidence that they would have relinquished the guns to Adam Montgomery, although there is evidence that the guns may have been in the home for some short or long period of time. There are both claims, but I think that without showing that Adam had control over the guns, that state cannot meet its burden on the receiving charges. With regard to the armed career criminal, again, the only issue is possession or having under his control the shotgun, and then on the other charge, the Stag AR-15. There is no, the evidence that he touched or controlled or possessed the guns, similar to the receiving charge. Add into it Mr. Sullivan's claim that at one point he sold the AR-15 from the trunk of his car, pulling it out of the trunk of his car and taking it to Mr. Sullivan's home, subsequently putting it back in the trunk of his car, taking it out and providing it to this mystery buyer. Would be evidence of certainly possession and control. And his subsequent statement that those events occurred, but they were the shotgun, not the Stag. His changes and inconsistencies in testimony, and his motive to cooperate with the police in order to get the deal that he ended up getting, which was his charges dropped. The level of credibility with regard to those charges, again, the state cannot meet its burden through the witnesses it has presented and the testimony it has presented. Thank you.
Thank you.
This is obviously, the evidence has to be taken in the light most favorable to the state, not most favorable to the defendant. I agree.
No, it's all set. Thank you.
It has to be taken in the light that the evidence most favorable to the state, not in the light inferences most favorable to the defendant. Here, the evidence has shown that the state can meet its burden of proof beyond a reasonable doubt that the defendant committed each one of the crimes that is charged. The testimony of Chris Frame and Kim Frame were shown that it was two long guns, the Mossberg 500 and the Stag Arms AR-15 rifle, both taken while Chris Frame was away from the home between September 29th and October 4th. We know that the Stag Arms rifle was recovered by Detective Wilson during the search of 315 East High Street, Apartment 1. This is an individual that had the defendant's cell phone number programmed in his phone. It was found less than a month later during a search warrant execution, with it also being found with several other firearms and 2 pounds of methamphetamine. In addition to those 2 pounds of methamphetamine, Your Honor, you also have the consideration of the text messages involving Mark Reed, and Mark Reed finding out that 4 days, if you look at that exhibit, 4 days after he'd been offered the Mossberg and told he had missed out, that he was flush with up, down, and Tino, which we know now is crystal methamphetamine. It's a fair and reasonable inference for the jury to be able to put together where did the defendant get the up, down, and Tino, probably from the person who's got 850 grams of it with his phone number in it, who now has the AR-15 that the defendant stole. Kim Frame's testimony, along with multiple witnesses who found this defendant, said that the guns were hot, so knew that the guns were stolen when he went to sell them, when he went to show them. And it shows that the guns were not lent out or taken without permission from Kim Frame, the way that was implied by defense counsel's questioning during her testimony, that she was asleep in her house and woke up to find the back door open and the defendant gone. That's corroborated by the defendant himself, again, saying in a recorded phone call that he was at Kim Frame's house and that she fell asleep. Not that she crashed, she fell asleep, and then he, quote, jetted, which we just heard a moment ago. Those are inconsistent stories that he then tells his wife, Kayla, and in one of those, the latter one, where he admits that he was there and she was sleeping and he took the guns. It's not disputed that he offered to sell the 2 guns to Mark Reed through Facebook. It is not disputed any of the details of those text messages, in which case he specifically states that his reason for sale is that they need the money so that they do not get evicted. Not Ishmael Garcia, not somebody else. We have not had one piece of evidence that's been presented that there was any sort of brokering deals that were going on for Ishmael Garcia. That is conjecture. We've not heard any evidence on that right now. Kevin LaBelle testified that when he saw both guns and he saw the defendant holding them, bringing them down from the attic at the Guilford Street residence, the place where he said he hid them in the walls and the ceiling, the same place that where Tara Hilbert told you he later bragged that he had an AR-15 and that he hid it in the walls. Plus, as he stated before, the fear that he had that the ATF was looking after him as a result of that possession. Both Mark Reed and Kevin LaBelle testified in cross-examination and were confident in the defendant's actions about possessing the firearms with the intent to sell the guns at the time. That's hands-on, that's possession, that's disposing of the guns, that's selling the guns, and the reason for selling the guns was for the benefit of himself, not for Ishmael Garcia. And again, both of those men's statements are corroborated. The video that we just saw, and I know we talked about it just a moment ago, so I apologize for repeating myself, but that's a video that shows, again, the defendant is trying to distance himself from the evidence of the crime. He's having not himself go to the Eco ATM and put his own license and have himself deposit that phone, which he had logged into his account and sent the messages to Mark Reed, but he has Kelsey Small do it, his girlfriend, assisted by Kayla Montgomery, who then, as the transaction is completed, he leaves from that area, making sure he's certainly not on the video that was snapped by Eco ATM. And his identity is clearly established through the rest of the footage at that particular video. Sullivan corroborates the testimony as well, having seen the defendant with both a shotgun and a rifle, most notably for that rifle transaction in exchange for the gun next to his house. And Adam's statements later on to him that if Kim had had cameras, then he would have been arrested. All of that evidence, Your Honor, taken in the light most favorable to the state, shows all three sets of the charges, the baseline of armed career criminal for the possession, certainly with a purpose to deprive thereof of being firearms, and then beyond that, receiving stolen property and the theft all came from this defendant. And the state feels very strongly that the matter should go to the jury because with the defendant's statements alone, or when you then start adding in the corroboration of just a handful of witnesses, and then you add in the corroboration of all of the witnesses that have testified, the state has shown that it will be able to meet its burden of moving forward. So we'd ask you at this time to please deny the defendant's motion.
All right. To succeed on sufficiency of the evidence claim, the defendant must show that viewing the evidence in the light most favorable to the state, no rational trier of fact could find guilt beyond a reasonable doubt. The state has set forth much of the evidence that's been presented. The court does not find that the defendant's motion is a viable one or that it should be granted. There, as noted by the defense, credibility issues are for the jury to decide, but there is ample evidence here that the defendant both possessed and had control of these firearms. As noted by the state, there was statements by Kevin LaBelle, Michael Sullivan, Mark Reed, all of whom communicated with the defendant around the firearms. Kevin LaBelle testified that he saw both of the firearms. Mark Reed also testified that there was communication about the sale of the firearms with the defendant. Kayla Montgomery testified that she saw the firearms in the house. Chris and Kim Frayne set the stage as to when those firearms were removed from the house. Based upon all of the evidence that's been presented at trial, the defendant's motion to dismiss is denied. All right.
My witnesses are all ready.
Okay. Approach for just a minute.
Yes, Your Honor.
We're going to take a 10-minute break.
All right.
be seated. Council, these are the revised, just the revised instructions for you. I noticed there's a formatting issue on. All right. All rise for the jury, please.
All rise for jury.
Please be seated. Attorney Smith, does the defense wish to call any witnesses?
Yes, Your Honor, we'll call First Officer Brunini.
Be careful, we're already for the police. Appreciate you.
If you could raise your right hand, do you solemnly swear the testimony you're about to give is the truth under pain and penalty of perjury?
Yes, ma'am.
Please have a seat. And could you state your name and spell it for the recorder?
It's Kenneth Brunini, Brunini.
Sort of apparent by what you're wearing, but could you tell us what you do for a living?
I'm a Manchester police officer,
How long have you been a Manchester police officer?
almost 16 years.
And what is your position within the department?
Currently, I'm a sergeant in the patrol division.
And what are the duties of a sergeant in the patrol division?
To supervise the police officers, to enforce the rules and regulations of the state of New Hampshire, and investigate crime.
Okay. I'm going to turn your attention to October 3rd of 2019. Did you respond to the Franz home at 252 Russell Street?
Yes, ma'am.
Do you recall what time you responded there?
I'd have to look at my report. I don't remember off the top of my head the time.
So if I showed you a copy of your report, would that help refresh your
Yes,
recollection?
ma'am.
Is this a
Thank
copy
you.
of your report?
It is.
And does that refresh your recollection about what time you arrived?
It does, almost 9:45 in the morning.
Okay. And in the morning, you did
Yes,
say?
ma'am.
9:45 in the morning. While you were there, and I have to limit some of the questions that I'm asking of you, okay? Did you receive a list of items claim to have been stolen.
Yes, I did.
And who did you receive that list from?
Christopher.
And do you recall what the items were on the list?
Yes, I do.
What were they?
It was one pistol, one rifle, one shotgun, a wedding ring, a watch, and then subwoofer speakers.
Okay. Was Kimberly Fran, did she come to the house while you were there?
I believe so, yes.
And did you speak with Miss Fran about the missing items that were on that list?
Yes, ma'am, I did.
And did she tell you, what did she tell you about whether she was aware or not of any of the items being stolen?
She told me she was not aware of the items being stolen.
Okay. Did she explain to you what happened to any of the items?
No.
Okay. So did you ask her about the items on the list?
I asked her, yes, I asked her what had happened.
And did she tell you whether or not she was
Sustained.
May we approach?
Yes.
That understanding, Your Honor, objection withdrawn.
So when you spoke to Miss Fran about the items on the list, and I think I asked you what she said and you answered, and then I asked if you asked her again. So that's what I'm focusing on. The second time you addressed the items on the list, right?
Okay.
I've confused you.
I'm
haven't I?
confused, yeah, sorry.
Okay, so I'm trying to go to something very, very specific. One of the items on the list was the ring, right?
Okay. Yes, it was.
Okay. And did she tell you that she had nothing to do with the disappearance of the ring, one of the items on the list?
I don't recall that specifically.
But- Go ahead.
I believe when I was speaking to her, it was in regards to all of the items.
Okay.
Nothing specific individual.
So you talked about each of the items, and she said that she didn't have anything to do with those items' disappearance.
Correct.
Thank you.
Ladies and gentlemen, that question and that answer involve a prior inconsistent statement. When I give my instructions to you, I will give you an instruction about prior inconsistent statements. But what I will tell you is you cannot consider the prior statement for its truth. The prior statement is to be considered by you in determining, in using it to determine whether or not to believe a witness. Okay, so it's not, a prior statement in this context is not to be used to determine whether or not that particular statement is true, but rather it can be used by you in determining whether and to what extent you believe a witness. So it's for the purposes of credibility.
No, I'm sorry. I have further questions.
Your Honor, you don't mind me asking from the table? I don't get
No,
too
that's
many
fine.
questions. Officer Bernini, can you hear me all right?
Yes, sir.
All right, if you, for some reason you can't hear me, please let me know, and I'll be happy to speak up.
Yes, sir.
I just have two quick questions for you. When you spoke with Kimberly Frayne, in speaking with her, did you make her any offers or promises in exchange for her sharing this information with you?
No,
And also, did you do a check for security cameras around the house?
I did.
In fact, you found there were no security cameras at that house or around that house, is that right?
Correct.
Thank you. I have no further questions for you. Thank you very much.
Thank you.
You said that you made no promises or offers to Miss Fran, right?
Correct.
You actually had no agenda walking in other than to investigate that case.
Correct.
Thank you.
So, thank you.
All right, you may step down.
Thank you.
I'd like to call Officer Slocum. Oh, may I be excused?
Yes, he may be excused.
Be careful, walking on here, please. Thank you.
Would you raise your right hand? Do you solemnly swear the testimony you're about to give is the truth under pain and penalty of perjury?
I do.
Have a seat, please. Could you state your name?
My name is Eric Slocum.
And could you spell your, actually both names?
Eric is spelled E-R-I-K. Slocum is S-L-O-C-U-M.
And what do you do for a living?
I work as a police officer for the state of Manchester.
What is your position there?
I'm a patrolman on the midnight shift.
And how long have you been with the Manchester Police Department?
7 years now.
And what are your duties as a patrolman?
As a patrolman, I respond to calls for service, investigate crime, arrest offenders, and deal with other kind of quality of life issues that might arise.
And were you in the street crime unit for a bit?
I was assigned temporarily on an overtime basis for about maybe 1 year with the Substance Abuse Reduction Group, where I got to work alongside detectives within our Special Enforcement Division, which is our narcotics unit.
And what you said about a year, what year was that?
2019.
I'm going to turn your attention to 2019. Did you, specifically December 19, 2019, did you have contact with a Kimberly Frame?
Yes, I did, while on midnight shift patrol.
And what was the nature of that contact?
About half an hour after midnight, I responded to the Shell station on Hanover Street as the clerk there had called 911 saying a female was passed out in a vehicle.
And did you investigate the female passed out in the vehicle?
Yes, I did.
And did you subsequently arrest her?
I did.
And what were the charges?
Just one count of possession of crack cocaine.
Okay. And it was possession as in it was on her person at the time that you arrested her?
At the time I arrested her, it was directly where she was sitting in the driver's seat.
Okay. Now, did you subsequently speak to Ms. Frayne?
Yes, she was transported to the station via the wagon, and then in booking, I processed her, which was doing fingerprints, photos, and basic search.
Did you end up talking to her about a prior investigation into missing guns from her home?
Yes, I did.
And did she give you some statements about what she knew about how those guns came to be missing?
Yes, she did.
And at that time, what did she say about how those guns came to be missing?
Sure. We just have it tailored the same balance that we have before.
May we approach?
Yes.
To the extent the objection is not withdrawn, it is overruled.
Thank you, Your Honor.
I'm going to ask you some questions about specific statements Ms. Frayne made to you about those missing guns. Did she give you a name of someone involved with the gun?
Yes, she stated Adam Montgomery was involved.
And did she say anything about when she I'm just trying to phrase the question right. What did she say about Adam being at her house?
She said that Adam was at her house the night when the firearms were taken.
Okay. And did she say anything about where, did she say anything about moving the guns that night?
She did.
What did she say?
She said she moved the firearms as Adam was staying on a couch at her residence that night.
Okay. And did she say what Adam was doing that night?
Adam was sleeping on a couch that night.
Okay. And did she say how long he was sleeping on the couch that night?
I don't believe she gave a specific time frame of when he was sleeping on the couch that night.
Did she say whether she saw Adam in the morning?
No, she left for work that morning and left Adam at the residence.
Did she say whether she said anything to Adam as she was leaving the residence in the morning on the way to work?
Yes, she told Adam to lock the door behind her.
Okay. So what she told you in December was the two of them were there. She had moved the guns. Adam and she went to sleep. And presumably Adam is still there in the morning because she told him to lock the door as she left.
Yes.
And she claimed that she was going to work, and that's why she told Adam to lock the door as she left.
Yes.
Thank you.
Just a moment, please, Your Honor.
Ladies and gentlemen of the jury, as I said to you earlier, a prior inconsistent statement in this context is to be used by you only in determining the credibility of the witness, not for the truth of the statement itself.
Thank you. Officer Slocum, I have just a couple of quick questions for you. When you first interacted with her, you responded to that 911 call, and that was a call because somebody had reported that an individual was passed out in a car, sleeping in a car. Is that right?
Yes, sir.
So when you're responding to a call about that, one of your initial concerns is always the health and safety of the individual. Is that correct?
Absolutely.
And when you spoke with Kim Frayne that night, in fact, I think your report documents, you noted that she was drowsy. Right?
Yes, sir.
You noted that she was lethargic.
Yes, sir.
You noted that she told you she was sleeping.
That's correct.
And before she said that, even when you first saw her, you saw that she was sleeping, right?
Correct.
No further questions, Your Honor. Thank you, Mr. Slocum.
Nothing further.
You may step down.
Thank you.
Any objection to this witness being excused?
No, Your Honor.
All right, you may be excused.
Thank you.
All right, ladies and gentlemen, the defense has now rested, so it is time for closing arguments. You can proceed whenever you're ready.
Good morning, ladies and gentlemen. When you rely on a lie, you reach the wrong conclusion. Kim Frayne lied. She lied about the missing guns. She lied about the .45 being in her car. She lied when she was asked about bartering guns for money. She lied about the long guns and moving them. She lied to protect herself and Ish. The state's case relies on lie after lie after lie. And the police in this case reached the wrong conclusion. Adam Montgomery did not steal the firearms from the Frains' residence. He did not possess or control those firearms that were missing, nor did he possess, maintain, or dispose of those firearms. Chris Frain told you that on Sunday, September 28th, all 4 of the firearms were in his bedroom. He told you that the 2 were under the bed wrapped in blankets, AR-15, and the 12-gauge shotgun. 2 in his dresser drawer, the .45 and the .380, both handguns. He then left for his business trip to New York, and he told you that generally he leaves on Sunday nights and returns on Fridays. But this time he told you he returned on October 2nd. That was a Wednesday. That was early. Kim Frain only learned that Chris was returning when he called her from the road, and Kim panicked. While Chris was away, she had been using drugs heavily. So heavily that she had gone through all of her money, but she was sick and still needed more drugs. You heard from Mike Sullivan what dope sick feels like. You're sweating, you're sick, you don't have control of your bowels, and your whole body is in pain. Kim called Adam to see if he had any drugs, but Adam was out as well. Adam drove to Kim's house and they both made calls to see if they could get drugs. Kim called Ish. Kim told you that Ish was one of her dealers and that Ish would drop guns off at her house. During her testimony, she told Attorney Smith, but she wouldn't call Ish if she didn't have money. When pressed on it, she agreed that if she didn't have money, she would barter. She and Ish had bartered for drugs before. She had allowed Ish to use her car in exchange for drugs, and she had allowed Ish to use the .380 in exchange for drugs. And we know that Kim got her drugs when she was sick. And we know that because when Chris came home, he never mentions that Kim is sick. And when Mike says she came over to the house the next morning, he never mentions that Kim was sick. Kim knew that she could barter for the drugs, and she did. Not only the .380, but for Chris's prized possessions. Not for sale, but to be used while Chris was away, like she had done before. So when Kim received that call from Chris that he was headed home, she freaked out because Ish still had the guns. Chris told you when he got home, he checked on those guns because he was going to the shooting range and he didn't trust him. You heard him testify that before this, he had noticed that money was missing and other small items. He also said that he knew Kim was using. And when he checked the guns, 3 of them were gone. But curiously, the .45 remained in the dresser drawer. The gun that Kim liked, the gun that she told you she had carried, the gun that was in the same drawer as the .380. But the .380 was missing. And the gun that was of the highest value, Chris told us that the .45 was worth about $1,000. Chris immediately became suspicious of Kim. And Chris was pissed. Kim told you that he tore the house apart looking for the guns. And he asked Kim repeatedly where they were. She denied knowing anything and kept repeating they must have been stolen. But Chris wasn't buying that story. Chris had a dog that barked when anyone came into the house. He did not believe that there was any way someone came into the house unnoticed. He also didn't believe that no thief would have taken one gun out of the dresser drawer and left the other behind. Kim knew more than she was saying, and Chris told Kim that if the guns weren't back, he was calling the police. That meant trouble for Kim. The next morning, Kim went to Mike Sullivan's house. Mike could help her get the guns back. She told Mike that Ish had stolen the guns from her house. Mike contacted Ish, but Ish told Mike the guns were not stolen, that Kim had exchanged them for drugs. When Kim was at Mike's house, Chris Frayne called the cops. And Chris called Kim while she was still at Mike's house to come back and talk with the cops. That's when Mike Sullivan knew that the police had been called. And he let Ish and Manny know the police had been called. At that time, Ish had to get rid of the guns. You heard from Mark Reed that it's pretty commonplace for users and dealers to be able to flip guns. He told you that he had done it for money. You get a cheap gun and then you flip it and get money for drugs. Ish contacted Adam to help him get rid of the guns fast. Having the cops around put everyone in danger. In danger of getting arrested for using, selling, or whatever else people do when they are getting high. Adam didn't need the guns to possess them or move them. Adam did not need the guns to move them. He had photos of the merchandise. You heard Mark Reed tell you he saw the photos. Adam started making calls as soon as possible. The sooner they moved the guns, the better. He called people. You heard Mark Reed said Adam contacted him about the guns. You also heard that while they were negotiating, the guns were gone. Another deal had been made. Adam messaged him too late. The guns were gone, and everyone's problems were solved. In 2019, the police do no further investigation into the missing guns. Even though you heard from Detective Bergeron Rosa that on October 22nd of 2019, about 2 weeks later, the AR-15 was recovered at John Sargent's house. After they were surveilling the residence, the SWAT team had gone in, anticipating that there were weapons and drugs. And they told you that John Sargent had been convicted of arms trafficking. John Sargent had the AR-15, other guns, a crossbow, and brass knuckles. But even after recovering this AR-15 that belonged to Chris Frayne, there was no further investigation into the missing guns. The idea that the guns were around for weeks is not reasonable. The guns had to be gone fast, and they were the same day. Too late. They were not found on Halloween being sold to two white guys, and they were not in the trunk of Adam's car. You also heard that in 2019, Kim was arrested. Officer just testified to that. and they spoke to Kim about the guns, and at that time she gave the police another story. This one was about Adam being at the house, her moving the guns behind the couch to be closer to her daughter, her leaving for work in the morning, and telling Adam to lock up. She mentioned that Adam was there that night. She hadn't mentioned that before, but the police did no further investigation. You heard that Mike Sullivan was arrested in November 2019 for drugs. You heard that the Manchester Police Department took him into custody and began telling him that they were going to take his kids. Mike told you, they told him, your kids are gone. Mike doesn't want to lose his kids, and he tells the police what he knows. He talks about the Frains missing firearms. He says Ish and Manny took the guns, and he mentions Adam. But in 2019, the police do no further investigation into these missing guns. The police do nothing about the missing guns until Adam Montgomery is arrested in 2022. And that's why you're here today. Because in 2022, the Manchester police were involved in a separate investigation. In 2022, the Manchester police wanted information about Adam Montgomery. In 2022, the police wanted Adam arrested and incarcerated. And the police begin to build their case to that end. And how do they do this? They look back at the people Adam was around in 2019. They look at the people who had had police contact with them. And they began contacting people in Adam's circle. They start with Kim Frain. And Kim tells them another story. Adam came over, she fell asleep, she woke up, Adam was gone, the guns were gone, but there was a crack pipe on the table. She doesn't tell them about Ish or Manny, and she doesn't tell them about bartering for guns. She continues to protect herself and her dealer. I'll remind you that when I spoke to Chris Frain about Ish, he agreed that he was scared of Ish and did not want to have any interactions with him. He too failed to tell the police about Ish until they asked him. And it was only then that he told them that Adam had told him Ish and Manny had taken the guns. The police go back and talk to Mike Sullivan again. In March of 2022, the police are actually looking for Mike because he didn't appear in court. He told you that he was supposed to go to rehab, but left court and continued to do drugs. You heard about the police raiding the house he was in Manchester, and you heard his description of that, Mike describing G.I. Joe style. When the police talk to Mike, this time about the guns, he gives them what they want. He tells them he saw the guns, he saw Adam with the guns, he was there for the sale, and he saw the buyer up close. But when Attorney Smith questioned him, you heard that when the police took Mike Sullivan on the ride-along to corroborate his story, he couldn't even find the house where he said he witnessed the sale. Mike said he got a close-up look at the buyer of the gun Adam had in his trunk, and yet he never identifies anyone, and the police do not do a photo lineup. When asked, Mike tells them he saw the AR-15, and another time he tells them he saw the shotgun. When he testified here, he said he could only see the barrel and the butt. and it was covered in a sheet. Mike cooperated, and you heard that his charges were dropped. The police talked to Kayla. At this time, Kayla was also in jail for the guns. She had charges for receiving the same 2 guns that Adam's charged with, the 2 guns from the Frayne residence. Kayla told you she didn't do it, and that her and her attorney had gone over the police reports, and that she was going to court to contest the charges at a hearing. Then the state makes an agreement with her. As part of that agreement, she's released on bail. And now Kayla wants to cooperate with the police. And she tells the police what they want to know about the guns. She agreed that when she spoke to the police, she had the benefit of the police reports, she had spoken with her attorney, and she had spoken with others about the case, like Tara Hilbert. After Kayla spoke with the police, the charges of receiving stolen property for the guns were dropped. Her welfare charges were dropped. But she was convicted of perjury, lying to the grand jury during the state's investigation, lying under oath. Kayla Montgomery is a convicted liar. The police then go to Mark Reed. At this time, Mark's in the prison. And he tells the police that Adam did message him about moving guns. Adam contacted him on Facebook Messenger, and he had photos and said he needed to move the guns quickly. Mark tried to negotiate a deal and received a message from Adam too late. Mark told you that he never saw Adam with the guns. He never saw the guns. Just the Facebook message about a deal. The police contacted Kevin LaBelle in 2022. At that time, Kevin was in a halfway house, but the police talked to him about information they had gathered. And the police asked him if he had bought a gun from Adam. And Kevin LaBelle said no. In 2023, the police go back to talk to Kevin LaBelle. This time, he's back in prison. He has a new charge. This time, Kevin tells the police he bought the gun from Adam. He held the gun, and he fired it off. Kevin checked all the boxes. And in fact, you saw Kevin LaBelle testify. And he wanted you to know that Adam sold him the gun, he held it, and they fired it. In fact, Kevin gave that answer to almost every question he was asked. But when Attorney Smith cross-examined him, let's think about his ability to remember other information. He couldn't remember what time of year he bought that gun. He couldn't remember what time of day. He couldn't remember his own criminal convictions.
Objection, Your Honor. Facts not in evidence.
Approach. The objection's overruled.
He could not remember where he worked. When Attorney Smith asked him to read his prior testimony, he said he couldn't read it. He had a concussion. But when the state asked him about his immunity letter and to read that, he had no problem. And he had no problem testifying that Adam had the gun and held it. Kevin LaBelle also got his consideration. In fact, the day before he testified, he told you that he had a felony charge reduced to a misdemeanor, and he received no additional time. You heard from Tara Hilbert. She was contacted by the police, and she told you that she continued to be friends even when Kayla was incarcerated. And her story supported Kayla, but she never saw the guns. The police spoke to her fiancé, Josh Zimmerman, 6 months later, and he told you that he had spoken with Tara after her interview, and his story was similar, but he never saw the guns. And what about the physical evidence, the science-based evidence, fingerprints, DNA? An officer told you that he recognized powder as if the AR-15 had been tested for prints. He talked about the evidence tape on the box indicating it had gone to the state lab. And yet you've heard nothing from the state about any information or results. What does that tell you? That science-based information does not show Adam had the guns. On April 1st, 2022, Adam was arrested for selling the guns. On April 4th, 2022, Kayla was arrested for receiving the guns. Her charges were dropped after she spoke. The state wants you to believe that all of their witnesses are saying the same thing, but if you look closely at each one of the inconsistencies, each one has a possible motive to help themselves or another. The testimony you have heard is like what I mentioned, a game of telephone. What happened to the guns? Stole, traded, bartered, pawned. What guns? The AR, the .38, the rifle, the long gun, the handgun, the big gun. Who knew something? Chris, Manny, Kim, Mike, Adam, Mark, Kevin, Tara, Josh. Where were the guns? In the attic, in a trunk, at a house, in the walls, in a ceiling. Who bought the guns? 2 white guys, a Hispanic guy, 2 black guys. What were the guns in? A blanket, a sheet, in cases. The state has to prove these charges to you beyond a reasonable doubt. And when you look at the testimony and evidence in this case, there is doubt. The inconsistencies cannot be made into one consistent, believable story. For example, the theft of the guns from Kim's house. You can see this in different scenarios. Kim needed drugs, but she was out of money. She reached out to her dealer, Ish, but did not hear back, so she called Adam. But before Adam arrived, Ish came over and gave her the drugs she needed. In turn, she gave him the drugs. Adam arrived. She was passed out from the drugs after being up for 3 days. She bartered for the drugs, allowed the guns to be used, and returned before Chris was home. But Chris came home early. The police were called, and the guns had to be getting rid of. Or another scenario, Kim called Adam and he came over. They were both in need of drugs. They called for the drugs, but no one came. Adam left before Ish came over, and Kim exchanged the guns for drugs when Adam was gone. Or a third, Adam came over when Kim called. They did drugs. She went to sleep. He took the guns and took them home. If any one of these scenarios is reasonable, then there is reasonable doubt. The same is for the sale of the guns. Based on what you heard, you could conclude that Adam did help Ish in selling the guns based on the photographs. He never had the guns, therefore he did not possess or control them. Or in another scenario, looking at the evidence, you could conclude that Ish came to Adam trying to sell the guns. Adam didn't have money, but offered to help Ish move the guns in exchange for
Objection, Your Honor.
drugs.
Those are facts, not evidence.
Sustained.
If both of these are reasonable, that is reasonable doubt. Anyone can accuse a person, even the police. The police wanted Adam Montgomery. They used the police you saw during the trial to try and corroborate their conclusion. The information the police generated using the tools of pressure, threatening, or offering them something they wanted. The evidence that you have heard was manufactured over time for the police. When you base your investigation on a lie, you get the wrong conclusion. At the beginning of this case, you were asked if you could find Adam Montgomery not guilty if the state could not meet their high burden beyond a reasonable doubt. You all agreed that you could. The reason to find Adam not guilty here today is bigger than just Adam Montgomery or any of the other witnesses. It is to maintain a criminal justice system that does not allow the police to make a single conclusion about a person and then conduct an investigation that only looks for the evidence that supports their conclusion and get the result they are seeking. Adam did not steal Chris Frayn's guns. No one did. Kim lied after she had traded them for drugs. When the police were called, the guns had to be moved. Adam made calls to move those guns. This did not require him to possess them. He communicated with people by phone, text, and Facebook message. Drug dealers do not trust their users. The reason that they're in business is because those folks want drugs. Ish was smart enough not to trust anyone with the guns. He controlled what happened to the guns. Adam made the connections with the people, the potential buyers, but he did not control the guns or who got them. We ask you to find Adam Montgomery not guilty.
Your Honor, if we can have a moment just to move the television if the jurors need to take a stretch break.
As you may. If you want to stretch, this would be a good time.
quotation of what those folks said when they took that stand, or what they said in a previous statement. And is that what you got? It's not. One thing that I agreed with Attorney Smith about, one thing that we got from these stories that we heard from the folks that came here and testified, Attorney Smith said in her closing that Mike Sullivan came up and he told the truth about his interview, what he knew in his 2020 interview. And we talked extensively about that, what he knew. And she said he told the police that Ish and Manny was there, and he mentioned Adam. Was that what he said? Was that what he testified to when he took the stand? I read his quotations to him. He adopted those. He said, yeah, that's what I said. That's what happened. And what I asked him, you said Ish and Manny took the guns, and Adam had the guns. I couldn't agree more with what Attorney Davis said. He did tell the information that he knew back in 2020. He said Adam had the guns. And then he was asked, did you see the guns? And he said, see him, I held them. The shotgun and the AR-15 rifle, I held them. Adam had the guns. That was his statement. He said, yep, that's what I said. So when we quote people, we want to make sure that we're using the right quotation. And we're encompassing the full story. So the surrounding statements that are associated with that quote, not just picking and choosing. He said Adam had the guns, both guns, the big boys, the 2 long guns that were stolen that night. And he clarified with us. He told us that when he referred to Ishmael, Garcia, and Manny, he was referring to the pistols. That was his evidence. That was his testimony. That was his truth. So there's the evidence of Ishmael Garcia or Manny. And we should have added during closing some phone call between between Ishmael and the defendant. Where did we hear that? Not a part of this case. Speculation by the defense to fit their story. Adam had the guns. There's another concerning thing that you were told just now, and that's that in 2020, the Manchester police wanted everything they could get on that man. Where did we hear that? Did one of the witnesses say that? Why? Why would the Manchester police care about Adam Montgomery? That's not anything we heard in this case. That they were all out to get Adam Montgomery? For what? Because he possessed guns. When he was told 3 or more times, you can't have guns. Felony conviction after felony conviction after felony conviction, being told, no, you cannot have guns. And still he sold them. He stole them. He possessed them. And he distributed them to people in this city, people like Jonathan Sargent, who was apprehended with it shortly after. That's one reason to care about who he is. To concoct stories, to get witnesses to say what you want them to say. What evidence did we hear of that? But they were right. Mr. Sullivan, 2020, came in and told them what he knew. That's what she said. And he did. Adam had the guns. The 2 guns that he's charged with stealing, the 2 guns that he's charged with possessing, and the 2 guns that he's charged with selling or disposing of. The 2 big boys. So there's no evidence of Ishmael Garcia. And that's because it didn't happen. The story that you were just told was just that. It was a story, not based on evidence. I want to continue talking about what this case is not about, ladies and gentlemen. This case, it's not about Mike Sullivan's drug use, his drug addiction, his charge for petty possession. This case is not about that. It's not about Kim Frayne being slumped over sleeping in a car with drugs on her person. It's not about her drug use. It's not about her addiction. This case isn't about Mark Reed. It's not about the things that he told you he did on the stand, like do drugs, sell meth, sell crack, sell heroin. This case isn't about that. This case isn't about Kayla Montgomery, her drug use. It's not about her conviction for perjury on another matter. It's not about that. But notice that that's what you got a lot of. These convictions, the drug use. People that came in and were open and honest about some of the roughest times in their lives, things they've fought to get out of. It's not about their drug use, and it's not about their charges or convictions. And the defense wants you to focus on those things. They want you to focus on everything this case isn't about. So at the end of the day, you won't see what this case is really about. That man going into his trusted friend's home, stealing from her, betraying her trust. Her trust as an invited guest. And in the time that followed that, possessing firearms, knowing that he couldn't, selling those firearms for drugs or money. That's what this case is about. Don't let those other things distract you. They're a distraction. So with that out of the way, I want to talk about the theme of our story. I want to talk about something that they didn't. I want to talk about the truth. And again, the truth is what you got from the witnesses. It's true they raised many questions. Those weren't relevant questions. Those weren't questions that should give any of you any serious pause when you're considering what the real evidence is in this case. They were attempts to distract you. And again, the truth is he stole those guns, that he possessed them, that he sold them. This is a remarkably simple case. Again, the best evidence in this case, not her statements, but his, the defendant's. What the defendant told us, that's what we're asking you to rely on, his words. And what did he tell us? He told us that he stole the guns. That's a pretty big detail. He told us that he possessed the guns. He told us that he sold the guns. And he told us how he did it, who he betrayed to get them. That's the truth of this case. That's the truth that you were given over the last few days, folks. That's the only truth that there is. And how do we know what the defendant said? Well, he made statements. He told witnesses things. The witnesses that testified to his various statements, drastically inconsistent with one another, but with consistencies that matter, and we'll go over those. So we have his various statements. We have the jail call that you folks just heard, that we listened to just an hour and a half ago. And we have his messages. Those messages frozen in time, as Mark Reed told us. And so what was his first statement? His statement to his wife. The first thing he told her about this incident shortly after it occurred. He told her that Kim Frayne was sleeping, that he went to her house. Her door was wide open. Her dog didn't bark. He went there. She was sleeping. He woke her up. She hadn't crashed. She was sleeping. Not crashed. She was asleep. He woke her up and she said, "Oh, my guns are gone." That was the first story that he told. He told his wife. And she came in here and she testified to it. And I guess the rest of that story would have been that he left. And the second story that he told to his wife again, after she confronted him, after she saw him dealing those guns to Ish, to Manny, and to Mike, attempting to sell them what they knew were stolen guns. She confronted him. This was her colleague. This was her friend, a close friend, someone who had done favors for her family. And he told another story. And what was that story? We got it from Miss Montgomery when she took the stand the other day. She told us that he said, that defendant, I went in, she was sleeping, the dogs didn't bark, I took the guns, I concealed them in a sheet, and I left. And that's consistent with what she saw. She heard him come home afterwards, and the next day he was trying to broker that deal. He was trying to sell those guns to Ishmael Garcia. He was trying to sell the guns to Manny, and he was trying to sell the guns to Mike, and they said no, because they knew the guns had been stolen. And then we have his third statement, and that's from the jail call, again, that we just listened to. He was there. He was hanging out with her. They were hanging out. She started falling asleep. Again, falling asleep, not crashing, not nodding off. She was falling asleep. He said goodbye, and he jetted. That's the story, the third story that you just got about what happened that evening. And then you also heard a fourth statement from Michael Sullivan. He told us what the defendant said, and he told us the manner in which the defendant said it. He'd been confronted about the cameras that Miss Frayne said her neighbors had pointed at her house. That confrontation while the defendant was doing drugs with Mike Sullivan. And remember what Mike Sullivan said. He said that his wife, the defendant said that his wife was getting ill. She was getting dope sick. He needed more drugs. And I gave him more drugs for his wife to prevent her from being ill. Because it's so bad when you're drug sick. You need more. You need a little more to hold you over so you don't get ill, so you can control your bowels. And that's what was happening to Kayla. And what did the defendant do? What did we hear the defendant did with those drugs that he'd been given for his wife? He took them himself. And why did that matter? Why did it matter that Mr. Sullivan told us that story? It's why he was in the car with him next. It's why he left with him to ensure that the defendant didn't do more drugs that were intended for his wife, to prevent her from becoming ill. And that's when the defendant first told Mike Sullivan that he'd stolen the guns. If she had those cameras, I would already be in jail. Not Ish, not Manny, me. I would be in jail. And we heard that she didn't really have cameras. If she had those cameras, I would already be in jail. And then, ladies and gentlemen, we also have the defendant's own statements, frozen in time. His Facebook messages from the day after he stole the guns, trying to get rid of them. The defense wants you to believe this was him brokering. And I think that means we need to look at the actual messages, and we need to go through those messages, and we need to see what this man is actually saying in those messages, because that tells all. And Your Honor, if the jury can just be told that they can move if they need to see.
You can move if you need to.
And ladies and gentlemen, you'll get these when you go back to deliberate. So the first message, the first call. So this is a call from the defendant to Mr. Reed. And importantly, it's dated October 3rd, 2019 at 10:26 a.m. Yo, Mark, hit me up, dog. I got something you're really gonna like. You gotta hit me up now, ASAP. You're gonna miss out, bro. You don't hit me up right now. Should girls phone or something to call and call. I got something you're really gonna like. I do. He's not saying Ish, not Manny, not the boogeyman that you haven't heard of. You gotta hit me up now. Not someone else, me. If you don't hit me up now, and he provides phone numbers. And the first one, it appears to be a typo, and he clarifies that in the second number that he provides. And when I say he, I'm referring to the defendant. He sent these messages. That's not in dispute in this case, from his fingertips. And how can they be disputed? 858-3393. That's the number that he provides. Why is that important? He provided that number on October 3rd, 2019. And we heard that when Jonathan Sargent was apprehended with one of the stolen guns, in addition to everything else he had, the meth, the pounds of meth, the money, all those other drugs, or all those other guns rather, that number was in his phone under a contact named Montgomery Adam. And you heard what wasn't in his phone. You heard there was no Ishmael Garcia, no Manny. The police looked. Why would they look for other information that would rule other people or make them suspects in this case if they had blinders on for this man? Why look for evidence that would refute that he was the only person that stole those guns, that he was the only person that possessed those guns if they had blinders on for one person for some unknown reason? That number of the defendants tied to that gun or that man that had that gun in his phone under Montgomery Adam. Someone that was later sentenced to 13 years in prison for possessing that gun. Someone that dealt in meth. And why is that important? We'll get to that. Oh, then you're gonna miss out because I'm not messaging this shit. I'm not messaging this. I don't want it on Messenger. I don't want it on Facebook. I don't want it preserved in time for a future investigation into what I'm doing. Don't want it on Messenger. I'm not messaging it. There's a house phone there. You guys have cell phones up there. You guys have some type of service. And just before that top message there, you're gonna miss out. We know from Exhibit 35, which you'll get when you go back to deliberate, that Mr. Reed responded to the defendant, and we know what he said. He said, "Yo, what up?" To which the defendant responded, "Do you not get, I said call?" And Mark Reed responded to that, "I can't right now, bro. I'm in Bristol." And then we have these messages. So Mark Reed responds, "Yo, what's up? I don't want this on Facebook. Call me." And he gave his number. Facebook is too choppy. It's too notch. I don't need stuff like this on message and then on Facebook, dog, you got? I don't want it on Facebook. I don't want it on Messenger. I don't want it preserved in time. What's the defendant so concerned about here? What's he worried about being captured or memorialized? It's evidence of his crime. It's evidence of his criminal conduct. It's evidence of his theft of those firearms. And here they are. I have something right now that you've been looking for. For grip, bro. Hit me up. ASAP. Hit me up. I have something. Not someone else, not some mystery man. I do. And Mark Reed responds, "If it's metal, I want it." And Mark Reed came here and he told us what metal meant when he was sending that message. He was talking about firearms. If it's metal, I want it. And you heard him say, it was easy to move firearms. Quick money for firearms. The defendant responded, "It is, bro. The big boys." Remarkably simple case, ladies and gentlemen. It's the big boys. The big boy metal. Marguerite responds, "How much?" Remember, he's interested. "I can't hold it. First come, first serve." First come, first serve. This man was in a rush to get rid of stolen property, property that he had stolen. He didn't want to be caught with him. And then what do we have here? We have the unsent Facebook messages. And when Mark Reed was here, I asked him, what was in those messages? And he looked at all of you and he told you what the messages contained. They were pictures of an AR-15, Stag Arms AR-15, and a Mossberg 500 pump-action shotgun, a 12-gauge. The two guns that had been stolen the night before, stolen by Adam Montgomery. And why did he unsend those messages? It's what we've been talking about. He didn't want evidence of his crime preserved in time. Mark Reed was able to come here and talk about it, though, tell you exactly what he saw then. We also have the context of the rest of the messages that explain what he saw. "I want," or "How much? I want." To which the defendant responded, "Which one do you want? Both of them or which one?" So we're talking about two items, both or which one? Price of each. And then there's another message that's unsent. And then the defendant says, "But we can work something out. What's some other stuff? This is why I need you to call me." But I literally have people blowing me up right now as we speak. But you my dude, so I called you first. I literally have people blowing me up right now as we speak. And he saw that there's another missed call. He's trying to get a hold of this individual, trying to call him. Mark Reed says, "I want the 12-gauge, but I don't got 3V. I want the 12-gauge. Again, the Mossberg 500 shotgun, pump action, 12-gauge shotgun. But I don't got 3V. Because 8 get a V, pick up and down. And we heard that up is a stimulant, meth, or crack. Crack. Up is crack. Down is heroin. And we heard that this is a communication that's disguised. It's talking about drugs, but they're using other words for them. And Mr. Reed explained what those words mean. Up, crack, down, heroin. The defendant responds, "I'll take it." Now let's back up to that story that you heard. And I said I was moving on, so I apologize, but I have to say this. The defense story about the defendant being some proxy for someone else, just negotiating the sale for a buddy. You were told that Ishmael Garcia was the defendant's supplier, that he supplied him with drugs. The defense then got up here and said, "Oh, well, he was selling these guns to get drugs to give to his supplier of drugs. So I'm selling guns to get drugs to give to the person that supplies me drugs." That's what they got up here and told you. "I'll take it." "How much?" "I'll take a stick for the pump." And Mark Reed told us that a stick means a stick of heroin or fentanyl. A finger, which is 10 grams. "But I also need like $80 cash." And You heard about a message from September 25th where the defendant says that he's facing eviction, that he needs to get the bread. He needs the money. So I'll take a stick for the pump. I will take a stick for the pump. Not Ishmael, not Manny, me. I will. But I also need like $80 cash. I can't wait around, bro. I can't wait around with it, bro. So I mean, if you hit me up before anybody else does, then it's yours. But if somebody else comes here with the bread, then I got to take it. Let's unpack what that statement says. I can't wait around with it. What are we talking about in this conversation? We're talking about the stolen firearms, the big boys. He has them. He can't wait around with them. They're in his possession. So I mean, if you hit me up before anybody else does, remember there's hundreds of other people that he's reached out to that are hitting him up for these guns. And it's yours. But if somebody else comes here, I'm going to sell them. Here to my house. Remarkably simple case, folks. A conversation so frozen in time. He puts himself with the guns that he had just stolen, and now he's offering them for sale. If somebody comes here with the bread, then I gotta take it. Because we need the bread ASAP, bro. And what else does he say? We're about to be kicked out of my any day now house. And I told you about the earlier message. And again, you're gonna get all these messages. You're gonna get the actual verbatim statements. You'll also get these photographs. If somebody comes here to my house, we are about to be kicked out any day now. And you heard from Kayla. She told you who lived with them back then. The defendant, herself, their 3 children, Seamus, Declan, and Harmony. Ishmael didn't live with them. Remarkably simple. Ishmael wasn't one of their housemates. Manny wasn't one of their housemates. The 2 of them and their 3 children. And then we have the messages from later on that day, almost 3 o'clock, where Mark Reed says, yo, remember he's interested. Yo. And then a phone call. The defendant calling him. And again, this is on October 3rd around 3 p.m. The defendant says, you missed out. And what's the next communication, folks? October 2nd, or October 7th. October 7th. Just a few days later, and what is the defendant saying? Got fire up and down, and Tina. Let's unpack that statement. He's offering these guns for sale, for drugs, for money. He says you missed out. And then what does he say here? He's saying I have drugs. Got fire, up, crack, down, heroin, and Tina. And what did it tell us Tina means in drug language? He said it means methamphetamine, crystal meth. And who sold crystal meth back then? And who had the defendant's number in his phone back then under Montgomery Adam? And who had that firearm 20 days later? This is a remarkably simple case, ladies and gentlemen. Again, those are the defendant's statements. We all agree that those are the defendant's statements. He wasn't doing this as some proxy for some other person. He was doing them for himself. He refers to himself and only himself as needing the money. He refers to himself and only himself as having the guns. He refers to himself and only himself as needing the drugs. He refers to himself and the people that live with him as facing eviction. Ladies and gentlemen, he provided us in those messages all the evidence we need to find him guilty of not only the mere armed career criminal, but also the receiving stolen property, also the theft by unauthorized taking for both the rifle and the shotgun, the two guns that they were discussing in those communications. And so now I want to talk about the evidence that corroborates his statements, what he said in those messages, what he said to other individuals, people that were there at that time. And when I discuss this, I want to remind you, these folks, they weren't in cahoots with the police. They weren't in cahoots to play Get Adam Montgomery for some unknown reason. These are folks that weren't connected, except for Tara Hilbert and her partner, Josh Zimmerman. There were folks that didn't like the police. And there were folks that had no connection with anyone else. If they wanted to cook this up, ladies and gentlemen, they wanted to get the defendant, wouldn't all of their stories align? Isn't that what you heard from the defense? We're going to say all of their stories align? No. You heard their statements. You heard their testimony. They all offer one piece of the puzzle. They all offer some detail that puts one or both of those guns in the defendant's hands. They weren't in cahoots. These people don't know each other. They don't care about each other. They didn't get together and say, oh, how can we cook this up? I want to talk about their statements and how they corroborate what Adam Montgomery said. First, the type of guns. Kevin LaBelle came in here. He described the firearms that he saw that defendant holding, the ones that he was offered for sale. He described them down to a T. The make, the model, Mossberg 500 pump-action shotgun, model 500A. That's what we got from Kevin LaBelle, the type of guns. The shotgun, the Stag Arms AR-15 rifle that he saw that defendant with. He said he bought one of the guns, shot one of the guns. He tells us what type of guns they are. And Mike Sullivan, remember, we both agreed that he told the truth back in 2020. They told you that. He came in there and he told what he knew. And he said the defendant had both of the framed firearms. He had both of those guns. He didn't just see them, he held them. Shotgun and the AR-15 rifle. Mark Reed, again, describes the guns down to a T. Make, model. He saw them in the pictures the defendant sent him. Only the defendant sent him. Kayla Montgomery, she describes both the shotgun and the rifle. And yeah, she doesn't know the type of guns that they were, the exact make and model. She knows that it was a rifle, and she knows that it was a shotgun. And she's not a gun person, ladies and gentlemen. She never said she held the guns. She didn't. She told us that she didn't. She doesn't like guns, doesn't like them in her house. Still, she came here and she told you specifically that the gun that had been moved from the attic to under their bed, the shotgun that the defendant later went and shot with Kevin LaBelle, she got into a fight with him over that. She was trying to stop him. She didn't want him leaving because he's a felon and it was a stolen gun. Kim Frayne corroborates the types of guns. And so does Chris Frayne. Kim Frayne, the victim in this case, the victim who sat up there for hours on cross-examination and told the same story over and over again. And we talked about how it would be different than what she initially said. She didn't believe that her friend would betray her like he did. She didn't say that he was there that night initially. And she clarified that in her 2019 statement. He was there. And he clarified that in his statement. She corroborates his statement, ladies and gentlemen. So we have the type of guns. These are the individuals that saw Adam with the AR-15. These slides aren't blank. These are witnesses who saw him with the AR-15. And again, we have Mark Reed, the messages that he was sent, that he described, seeing these guns. Kevin LaBelle. And Kevin LaBelle, let's talk about him for a moment. You heard from law enforcement, you heard from Detective Dunleavy that he had 3 interviews with Kevin LaBelle. And we heard from Kevin LaBelle that in those first 2 interviews, he said that he had seen the guns. He said the defendant offered him the guns for sale, but he didn't buy them. And you heard that after detectives spoke with Kayla Montgomery, after they spoke with Kayla Montgomery, they went back and interviewed Kevin LaBelle. And he said, yeah, I bought the gun. I bought the shotgun. Someone that has no business being around firearms. They talked to him about his criminal history. They got his convictions out. He's a registered sex offender. You heard that. Someone that has no business being around guns, being anywhere guns are. And he's implicating himself. He's implicating himself in criminal activity. Is that to get at the defendant? No, he said he wanted to be here. Charges that he can face for providing that information, implicating himself, just like every witness did who came in here and testified. They all implicated themselves to some degree in criminal conduct. What you got from him was his admissions, which corroborate the defendant's statements. His admissions to his own criminal conduct, which corroborate that defendant. And he described the defendant with an AR-15. He also is corroborated by Kayla Montgomery. Again, she saw the rifle. Mike Sullivan, who said he held the rifle, and he was sure, 100% sure, that he saw the defendant sell it. That the defendant walked up to his apartment and he said, no, 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 that can't come in here. That defendant with the gun. And he said he didn't testify to the shotgun because he wasn't 100% certain, and he only wanted to come in here and tell you the truth. That's what he said. And we agreed that he was telling the truth back in 2020 when he made those statements that the defendant, and only the defendant, had those 2 long guns. Tara Hilbert. What did we hear from Tara? We heard that the defendant was scared about the FBI or ATF coming after him for selling guns. And she specifically said, he mentioned when he lived at Guilford Street, selling an AR-15 rifle, one that he hid in the walls in his attic. Josh Zimmerman corroborates that the defendant said he had a rifle that he sold while he was at Guilford Street. This is a remarkably simple case, ladies and gentlemen. These are the witnesses that corroborate that Adam had the shotgun, this defendant. Again, Mark Reed, he saw both guns. The defendant unsent those messages. Kevin LaBelle. What did we get from Kevin LaBelle? I bought the shotgun. I had it. I sold it back to him for 1.5 grams of crack. Kayla Montgomery. Remember that fight that she told you about where she was trying to help him? She was trying to prevent him from leaving. She didn't want him getting in trouble. She got emotional up there on the stand because she was reliving that event. That's evidence that you can take back to the jury room with you when you go to deliberate. That's evidence that you've gotten in this case. Her reliving that event on that witness stand under oath. The story about a shotgun that defendant had. And we had Mike Sullivan. He put that shotgun in the defendant's hands. And again, he said he held them. I only want to be 100% honest. Wrapped in a blanket or a sheet, a little detail like that, corroborated by all of these witnesses. The defendant said he wrapped it in a blanket or a sheet as he was leaving the home. That's what he told his wife. He wrapped it up as he was leaving. And what did Kevin LaBelle say? That when he brought those guns down from the attic, they were wrapped up in a sheet or a blanket. What did Kayla Montgomery say? That he stored them upstairs in a sheet or a blanket until he moved them downstairs under their bed. Little details. Kim Frayne, they were stored under our bed in a sheet or a blanket. Chris Frayne, they were stored in our bed under a sheet or a blanket. Minute details that these witnesses remember after several years. Remarkably simple. And the conversation about the camera. We know there were no cameras that day. No cameras. This story that Kim Frayne concocted about cameras, why would someone do that who traded these guns? Think about that. They're saying she traded the guns for drugs. Why make up this story? Why go to his wife with this story about cameras? Why play detective with him? Why try to get him to admit to this? Remember, everyone that they associated with back then knew that he stole the guns. Everyone told her that. Mike Sullivan said the same thing. Everyone knew. And why did everyone know? He was offering the guns to hundreds of people. He had hundreds of people hitting him up. This wasn't a secret back then. Everyone knew. And this camera conversation corroborates that the guns were actually stolen. Why would someone that traded the guns for drugs make up this story, concoct this story to get the defendant to admit what he had done? And who corroborates this conversation other than Kim? Mike Sullivan. He was there for one of them. And then when they left, the defendant said, "No way, I would already be in jail if she had cameras." Kayla Montgomery corroborates that this conversation several years ago, it happened. She told the defendant, and he was concerned. And that's how we know that when he left, he concealed the guns. She told us that the defendant was concerned. Adam at the crime scene, giving himself the means to steal these guns. Each statement you have from Kim differs slightly, but in 2019 she told the police that Adam was there. She said that he was there. Who corroborates that the defendant was there? Kayla Montgomery. She knew he was going there. They were going to get drugs. He was going to bring drugs back to her. Mike Sullivan. The defendant confessed to him multiple times. Of course he was there. And each statement by the defendant, including the jail call that you just heard, corroborates that he was there. He had the means to do this. He had the opportunity to do this. Remember, she was sleeping in each of his statements, sleeping, not crashing, not doing anything to get drugs, sleeping. And what did she say? When confronted with this crashing theory, she said, "I needed to sleep. I'd been up for days. I needed to sleep. I slept." That the guns were stolen, the defendant told Kevin LaBelle that. Kevin LaBelle said that he knew the guns were hot. He knew that because the defendant told him. Kim Frayne has said from the get-go, from her first statement, the guns were stolen. I didn't trade them. She came in here, she looked at all of you, and she said, "I didn't trade them. The guns were stolen." Mike Sullivan knew that the guns were stolen because the defendant offered to sell him the stolen guns. The defendant admitted to stealing the guns. Kayla Montgomery, again, the defendant confessed to her. Mark Reed, he said he knew the guns were hot. That was his business. He's a changed person now, but that was his business. Chris Frayne, he also said the long guns were stolen, that he didn't believe Adam when he came and told him about the trade to Ish for the 380, not the long guns. The guns were stolen, and that the defendant obtained the guns. Mark Reed corroborates the defendant's statements that he obtained the guns. He told you what was on those pictures. You have the context of that communication that he had with the defendant. Kevin LaBelle saw those two guns, described them to a T. Kayla Montgomery, the rifle, the shotgun. Mike Sullivan, the describes the guns, the tactical shotgun that he saw the defendant with the extra ammunition on the side. The same description that Kevin LaBelle gave, the same description that Chris Frayne gave. Mike Sullivan, who saw the defendant with these guns, and Kim Frayne, who knew that they were taken by him. Everyone knew that they were taken by him. But the defendant possessed the guns. Again, a long list, not a blank slide. People that saw him with the guns. That the defendant sold or disposed of the guns. The same individuals, the witnesses that came in here and testified to all of you. There's no question, folks, that he stole those guns, that he possessed those guns, and that he sold those guns for drugs and or money. The statements that we got from those individuals, they corroborate the large details and the small details. The details like the blanket, those are small details. And the large details like his confessions, his admissions, seeing him with the guns. Corroboration of the defendant's acts. Again, if all of these witnesses were in cahoots to get that man, all of those boxes would be checked. There'd be a check next to every one. I's dotted, T's crossed, check next to each one of them. But what do we have? We have the witnesses coming here to you, telling their bit of their story, what they saw, what they heard, what they in fact did. This wasn't as the defense called it, a case about getting the defendant. This was people coming in and telling you what they had seen, what they'd heard, what they'd done. I want to talk about the law. But before I do, we heard a lot about criminal histories in this courtroom. Were those criminal histories, did they matter? Did they do anything to change the facts that we heard here? The only criminal history that matters in this courtroom is the defendant's, convicted on 3 or more occasions of the requisite criminal felony offenses, being a career criminal, in other words. You were read a stipulation. You read a stipulation. The parties aren't in dispute that he has those requisite felony offenses. His criminal history is the only one that matters here. So again, armed career criminal, 2 counts of armed career criminal, 1 count for each of the stolen guns, 1 count for each of the guns that he possessed. Theft by unauthorized taking, again, 1 for each of the guns. Receiving stolen property, 1 for each of the guns. So, armed career criminal, like I said, career criminal, possess a gun. And the judge is going to tell you, when she reads the law on armed career criminal, that it contains 3 elements. 3 or more qualifying convictions, not in dispute. Knowingly having or owning or having control over the long gun or rifle, depending on the count that you're looking at. So knowing, possession. There's the rifle that was recovered from Jonathan Sargent's house with pounds and pounds of meth, with money, with other guns, with crystal meth, heroin, fentanyl. He received 13 years for trafficking in drugs, himself being a felon in possession. Let's talk about receiving stolen property. So with receiving stolen property, the judge is going to tell you that it requires proof that the defendant knew that he knew that the 2 guns had been stolen, that he received or retained them with the purpose of depriving the owner thereof. We know that he knew that the guns were stolen because he stole them. Everyone was talking about these stolen guns. The victim confronted him about the stolen guns. and he retained them. The witnesses all told you that the guns were stolen. And was his purpose to deprive the owner of those guns? Yes, we see his purpose. We have it in his messages, selling them to someone else for drugs and money, hiding them in the walls, in the attic. So armed career criminal and receiving stolen property, there's a requisite timeline associated with that. And that's September 29th, 2019 through October 22nd, 2019. That's the time period when he had those guns and when he held on to those guns, so receiving. September 29th, 2019 through October 22nd, 2019. So finally, theft by unauthorized taking, again for the AR-15, for the shotgun. The judge is going to tell you that the law requires proof that the defendant obtained or exercised control, unauthorized control, over the rifle and shotgun with that same purpose to deprive Chris Frayne of his guns. He did that when he took the guns out of the Frayne home. He acted with intent to no longer give them back. Remember, Kayla just wanted him to give those guns back. He didn't. He sold them. So with the intent to deprive the owner thereof. And the timeline associated with those two charges, the theft by unauthorized taking, that's September 29th through October 3rd. Remember the week that Christopher Frayne was out of the house. He was gone to work. So if all of these witnesses were in cahoots, they all wanted to get the defendant, Kim Frayne would have just said he did it. She wouldn't have made this story up about the cameras. And that's not what we got from Kim Frayne. She said she fell asleep, that when she fell asleep, the defendant was still there. When she woke up, he was gone. The guns were missing. And why didn't he want those messages, those Facebook messages? Why did he want to hide them from you? Because he knew how damning they are. And how does common sense tell us that we know he was trying to hide them from us? Well, go back, look at the Walmart footage in your deliberations. There's a camera on that Echo ATM machine, and he wanted to be out of view. And we know that he was out of view. He had control over someone else, that he had deposit those phones, recycle them. He didn't want to be associated with them because he knew what was on them. He knew that that phone linked to that account. Remember, he logged into the account on that phone, the Facebook account, linked to those messages. He wanted nothing to do with them. And yet he was captured on camera, linked to that phone being deposited in that machine, that phone tied to that account, tied to those messages. He was in control that day, enough control to get someone else to dispose of his evidence for him. And ladies and gentlemen, I mentioned something just then, common sense. That's what you take back there with you. Common sense as to why a wife would lie to protect her husband. Common sense as to why a multi-time convicted felon would lie about possessing a firearm. Common sense as to why the defendant would say he didn't want this stuff on Facebook and why he'd go to these extensive lengths to discard of all of that evidence. It's not surprising that when you get the truth from so many different sources, it all fits together. Not perfectly, but it all fits together. And you have a story from it. Little bits given by each witness throughout the course of this trial. Little bits that put each gun in that man's hands. The defense wants you to ignore all of these witnesses. They want you to ignore the messages that we've just gone over, that you've seen during this trial. I want to remind you, the state doesn't choose its witnesses. He chose them. He chose these people. He chose the soft targets. And the undeniable truth in this case that you heard throughout the course of this trial, that he had both of those guns, that he stole them, that he possessed them, that he sold them, means that you can return only one verdict. And that's the verdict that justice demands. That's guilty with respect to each charge. For being an armed career criminal, for receiving or retaining stolen property, and for theft by unauthorized taking for both of the firearms. In closing, simply put, the defendant was told, no, you can't do this. No, you can't possess firearms, after being convicted of certain requisite felonies. And he chose to possess the firearms anyway. That's the truth of this case. That's what you've seen. That's the truth that the defense wants you to ignore when you go back to deliberate. All of the witnesses that saw or heard the defendant with these guns or heard his admissions to stealing them. And you were all chosen because of your common sense, because of your ability to reason. And that's what you bring back there when you go to deliberate. And the state is asking you to find him guilty on each of the counts that you've been presented with.
All right, ladies and gentlemen, it's time for me to complete my final instructions to you. Maybe this is a good time. Just stand up if you want to take a stretch. I suspect these instructions will take about 10 minutes or a little more, and perhaps your lunches will be here, and you can begin deliberating. So in just a minute, I will begin my instructions. But as I say, this is a good time to take a short stretch. All right, members of the jury, I'm now going to complete my instructions to you. As I said to you at the beginning of this case, you will have all of these instructions, the ones I gave to you at the beginning of the case, and I will give to you now in writing. I will send back as many copies as the jury wants, so please just listen carefully. Please remember that in order to reach a verdict in this case, whether it is guilty or not guilty, your verdict must be unanimous. Prior inconsistent statements. In deciding whether to believe a witness, you may consider whether the witness made statements before trial that were not consistent with the witness's testimony at trial. Thus, if the witness made an inconsistent statement before trial, you may use that statement in deciding whether to believe that witness's trial testimony. Keep in mind that you may not use the statement made before trial as proof that the facts in the statement are true. The statement made before trial is only to be used by you in deciding whether to believe a witness. There are, however, two exceptions to this general rule that prior statements may only be used in assessing witness credibility. If the statement made before trial was made by the defendant or by a witness under oath, then you may use that prior statement as proof that the facts in the statement are true. I'm now going to discuss the definition of a crime and the crimes with which the defendant is charged. A crime is the breaking of a law for which the law provides punishment. All crimes have at least two parts, an act and a criminal state of mind. In deciding whether a person is guilty of a crime, you must determine both what the person's actions were and what his state of mind was. For a person to be guilty of a crime, he must have physically acted to do something that is criminal, and he must have had the particular state of mind. Unless a person both acted to do something that is criminal and had the required mental state, that person has not committed a crime. That means if a person either did not physically act to do something criminal or did not have the required mental state, then he is not guilty of a crime. To understand how mental state works, consider this example. Suppose two automobile drivers hit a pedestrian who was crossing the street. Suppose one of those drivers hit the pedestrian deliberately, whereas the other one did so out of carelessness. The two drivers would be guilty of different crimes, though they both committed the same act because each had a different mental state. Proof of intent. To prove that the defendant has committed a crime, the state must prove first that the defendant did certain acts, and second, that the defendant acted with a certain intent. Whether the defendant acted with the particular intent charged is a question of fact for you to decide. Keep in mind that there is often no direct evidence of intent because there is no way of examining the operation of a person's mind. You should consider all of the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted with the intent as it is charged in each indictment. The charged offenses. On charge ID 2008742C, the defendant is charged with the crime of armed career criminal shotgun. The definition of this crime has three parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant has been convicted of any combination of 3 or more qualifying felonies in this state or any other state under the applicable law. And 2, that the defendant owned or had in his possession or under his control a shotgun. And 3, that the defendant acted knowingly. Certain words in the definition need to be further defined. Possession. A person possesses an item when he has it in his physical custody or exercises dominion or control over it. Possession can be actual or constructive. Actual possession is when a person has direct physical control over the item. Constructive possession is the power to determine the use or disposition of the item. In either case, the state must prove that the defendant knew the location of the item and the defendant knew the nature of the item and that the defendant had custody of the item in the sense that it was in a place where it was under his control. In a case of constructive possession, mere access to the item is insufficient, as is mere presence in the location where the item is found. The defendant must have the power to control the item. Constructive possession can be inferred from all of the evidence presented, including any incriminating statements or any other circumstances linking the defendant to the item. Furthermore, constructive possession of the item need not be exclusive. The item can be possessed jointly with another. The term knowingly. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically intended or desired a particular result. What the state must prove is that the defendant was aware of the nature of his conduct. The parties have stipulated as fact that at the time of the allegations in this case, the defendant had previously been convicted in this state or any other state of a combination of 3 or more qualifying convictions as listed under the applicable law. That's the stipulation, one of the stipulations that I read to you earlier. Charge ID 2008743C, armed career criminal, rifle. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that the defendant has been convicted of any combination of 3 or more qualifying felonies in this state or any other state under the applicable law. And 2, the defendant owned or had in his possession or under his control a rifle. And 3, the defendant acted knowingly. Certain words need to be further defined. Those words are the same as the words that I defined for you in the first armed career criminal charge, so I won't read those again, but you should use the same definitions of possession and knowingly. I've also included the stipulation under this armed career criminal charge. On charge ID 1964101C, the defendant is charged with receiving stolen property, a shotgun. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant received or retained the property of another, to wit, a shotgun firearm. And 2, the defendant knew that the property had been stolen or believed that it had probably been stolen. And 3, the defendant acted with a purpose to deprive the owner thereof. These are the elements of the crime of receiving stolen property. Certain words in the definition need to be further defined. Receives means acquiring possession, control, or title. Property means anything of value. Knowingly is the same definition as I read to you earlier. That's the same definition to be used here. Purpose to deprive means to have the conscious object to withhold property permanently or for so long as to withhold property permanently or for so extended a period, or to use under such circumstances that a substantial portion of its economic value or the use and benefit thereof would be lost. Purposely. A person acts purposely when his conscious object is to engage in certain conduct. The state must prove that the defendant had the conscious object to engage in this conduct. The key words here are conscious object. To have a conscious object means to have specific intent. It means that the defendant desired to engage in certain conduct. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to do a particular act. Charge ID 1964100C, receiving stolen property, the rifle. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove, 1, that the defendant received or retained the property of another, to wit, a rifle firearm. And 2, the defendant knew that the property had been stolen or believed that it had probably been stolen. And 3, the defendant acted with a purpose to deprive the owner thereof. These are the elements of the crime of receiving stolen property. The words that need to be defined are the same as the words that I defined for you in the first receiving stolen property indictment, so I won't read them again here, but you have them here for your use. On charge ID 1964009C, theft by unauthorized taking, shotgun. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant obtained or exercised unauthorized control over the property of another, and 2, the defendant acted with a purpose to deprive another of the property, and 3, the property was a shotgun firearm. These are the elements of the crime of theft by unauthorized taking. Certain words in the definition need to be further defined. To obtain means to bring about a transfer of possession or of some other legally recognized interest in property. Property means anything of value. Purpose to deprive means a conscious object or intention to withhold the property permanently or for so long or under such circumstances that a substantial portion of its economic value or the use and benefit of it would be lost, or to dispose of the property under circumstances making it unlikely that the owner would recover it. Charge ID 1964098C, theft by unauthorized taking, the rifle. The definition of this crime has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant obtained or exercised unauthorized control over the property of another, 2, the defendant acted with the purpose to deprive another of the property, and 3, the property was a rifle, firearm. These are the elements of the crime of theft by unauthorized taking. Certain words in the definition need to be further defined. I've defined those for you in the first theft by unauthorized taking. Those same definitions are utilized here. In conclusion, members of the jury, let me say that this case is important to both of the parties, the state and the defendant. The principles of law that I have given to you are intended to guide you in reaching a fair and just result. You are to exercise your judgment and common sense with honesty, understanding, and due deliberation. As I said before, you should decide this case without passion, without prejudice, and without sympathy. It is your highest duty as officers of this court to conscientiously determine a fair and just result. Now again, as you were instructed during the general selection process, there is a presumption of innocence that applies and continues throughout the trial until the state convinces you beyond a reasonable doubt that the defendant is guilty of each and every element of the offenses with which he has been charged. And the defendant has no obligation whatsoever to prove his innocence in this matter, and that includes the right not to testify if he so chooses. When you have considered and weighed all of the evidence, you must make one of the following findings with respect to the charges before you. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the offense charged, you must find the defendant not guilty. On the other hand, if you find that the state has proved all of the elements of the offense charged beyond a reasonable doubt, then you should find the defendant guilty. And I remind you, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based upon reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. As I mentioned, we will select a foreperson at random at the end of these instructions. The foreperson acts much like the chair of a committee. He or she should make sure that you take up the issues that I have described, and should make sure that each juror has a full opportunity to present his or her opinions and arguments. I suggest that deliberations involve several components. You should each think for yourself about the evidence and the law. You should speak up and let your fellow jurors know your opinions, views, and positions. You should listen carefully and keep an open mind as to what your fellow jurors have to say. And you should make every reasonable effort to reach a unanimous agreement. The verdict that you reach must be a unanimous verdict and represent the considered judgment of each juror. In order to return a verdict, all 12 of you must agree on your verdict. As you deliberate, try your best to work out your differences. Do not hesitate to change your mind if you are convinced that other jurors are right and that your original position was wrong. But do not change your mind just because other jurors see things differently or just to get the case over with. In the end, your vote must be exactly that, your own vote. It is important for you to reach unanimous agreement, but only if you can do so honestly and in good conscience. If any questions concerning the law should arise during your deliberations, the foreperson should write out the question, sign, and hand it to the court officer. The court officer will bring them to me, and I will respond. You should take as much time as you like. When you have arrived at a verdict, let the court officer know, and you will be returned to the courtroom where the foreperson will render the verdict orally in response to questions that the clerk of court will ask. Please bear in mind in your deliberations there can be no communications with anyone other than the other deliberating jurors in the case or the bailiff. You are not to use your cell phones or smartphones to communicate with anyone, check email, or use the internet. Your verdict in this case must be based solely on the evidence presented at trial and the law as I have explained it to you. All right, ladies and gentlemen, we have picked, in this case, we seated 15 jurors, so that means we're going to select 3 alternates. So I have this very advanced technological system that I will use to select the alternates. So the first alternate is juror number 5. The second alternate, juror number 15. And the third alternate, juror number 1. So, ladies and gentlemen, the alternates will be taken to a separate location. You are not to discuss this case with each other or with anybody else. There are times when we do need to utilize the alternates for deliberations at another point. So for now, do not discuss this case, not with each other or with anyone else, okay? We're now going to select a jury foreperson. Juror number 13. Are you willing to serve as the jury foreperson? Yes. Okay. So I suspect, ladies and gentlemen, that your lunches may be here. I leave it to you to decide whether you want to eat lunch and then start deliberating or begin deliberations right away. I remind you, please, the alternates, don't discuss the case with each other or anyone else. Don't do any independent research. All right? Ladies and gentlemen, thank you so much for your time and attention this morning.
All rise for jury.
So thank you, everybody. I think at this point, is everybody just planning on staying in the building? If you go out at any point, make sure that you leave a cell phone contact information with the court monitor so that you're not far, and if there's any questions or a verdict, we can get to you.
Oh. Just in the next couple of minutes, I just want to know what time we should start breaking down some of the equipment here, try to get that out of the way.
You mean in terms of if we're going to use it for other things right now?
I know security staff needs to have their lunch as well, so I just need to.
Oh, are we going to lock it? Yeah, we will, well, hang on, let me check with security. We're going to send back all of the exhibits that have been marked as full exhibits except the firearm. I don't send the firearm back. I think the court officer can let them know if they need to see the firearm, that they need to let the court officer know, and then I would bring them back into the courtroom and we would show it to them here.
So, usually the recorder takes the exhibits back, right?
Yes.
So she would be the one informing them that the gun's not coming back and that if they want to see it, they have to call a court officer.
Yeah, I probably send a clerk in with her to do that.
Okay.
Yeah.
Great.
Yeah, typically I would maybe tell them here, but I didn't tell them here, and so, but I think no one has an objection. I'll just let the clerk tell them that if they want to see the firearm's not coming back, but if they want to see it, they can ask and I'll bring them back in.
Thank you.
All right, anything else? No? Okay. You're all set then. Thank you, everybody.
Thank you.
And counsel, I'm just going to go ahead and send 12 copies of the instructions back.